The Honorable Chief Justice and Associate Justices of the Supreme Court.
The House will come to order.
The Senate will come to order.
Move to consideration of House Bill 1542. And Sarah, I think you're going to give the report.
Thank you, Mr. Chair. Good morning. Very briefly, House Bill 1542 requires courts to provide interpreter services at public expense in all types of legal proceedings when a non-English speaking person is a party or is compelled to appear. The interpreters must be certified or registered by the Administrative Office of the Courts. Beginning January 1st, 2017, the state must pay 50% of the cost of interpreters appointed in legal proceedings for non-English speaking persons or for hearing impaired parties or those compelled to appear. Each court that appoints interpreters for non-English speaking persons is required to track and provide interpreter cost and usage data annually to the Administrative Office of the Courts by House Bill 1542 as well. There's a fiscal note on the books for this bill, and I'm happy to answer any questions.
Thank you. Do you have questions for staff? Okay, the gentlelady from the 37th District has joined us. Thank you for your patience, waiting for us to get to this point.
My pleasure. Thank you very much, Mr. Chairman. For the record, my name is Sharon Tomiko Santos, representing the 37th Legislative District. I do thank you for scheduling this bill for public hearing. I am honored to bring House Bill 1542 to you at the request of the Board for Judicial Administration. I believe this bill is vitally important to the integrity of our government as a system of laws, and especially to my constituents. You see, in the 37th Legislative District, more than 1 in every 4 persons is foreign-born. Many of these refugees, in particular, have emigrated from countries that do not have benefit of our rule of laws, let alone our cherished American precept of equal justice under the law as an inherent right granted to all in these United States. This promise rings hollow, however, when a person of limited English proficiency is required to interact with our justice system and is unable to comprehend the proceedings that affect him or her. Sadly, even some of our esteemed members of the judiciary are poorly informed as to the state and federal requirements for the courts to appoint or provide language interpreters to LEP persons, as is documented in the correspondence I've asked staff to distribute between Justice Owens and Judge Barbara Lindy, who is the presiding judge at the King County District Courts. I would draw your attention to the last paragraph in Judge Lindy's letter for particular note as to the importance here. I conclude my testimony by urging your support of this important legislation and ask that you listen carefully to the comments and testimony of practitioners in the field as to how this impacts their work. I'd be happy to respond to questions.
Thank you. Do we have any questions for the prime sponsor? Representative Roberts.
Thank you very much, Mr. Chair. We have done a number of bills about interpreters that have managed to leave out the deaf, and I'm very pleased to see that we're doing simultaneous interpretation of this proceeding. Are you clear in your mind that your bill is addressing those needs as well as those who are non-English speaking?
I think the question is a question of comprehension. And so if we are talking about language interpreters or interpreters for the deaf and hard of hearing, I personally don't see any difference. However, if the members of this esteemed committee see a need for clarifying language to that effect, I'm sure that that would be very acceptable to this prime sponsor.
Thank you. Do you have any further questions for the prime sponsor? Okay. Thank you very much, Representative Santos, for bringing the bill forward. Mr. Vice Chair.
May we please begin by hearing from the Honorable Judge Mary Yu, Latricia Kinlow, and Melanie McAleenan. And we have 7 people signed up in favor, no one is opposing, and another court reporter bill with 8 people who want to testify. So to the extent your testimony is cumulative, it would be helpful to hear less of it. Thank you.
Thank you. Good morning. For the record, my name is Melanie McAleen, and I represent the Board for Judicial Administration, which is the primary policy body that speaks for the judiciary as a whole. I don't think that I can improve upon what Representative Santos just said, so let me just tell you that the BJA believes that this is one of the most important pieces of legislation that they have brought to you in the last several years. We did try to balance the requirements that are being placed on local governments with some state funding, also recognizing the problem that you continue to face with the state budget, which is why we put the funding out until 2017. However, we did want to bring this bill to you this year. We think it's the right thing to do, and we do have some issues with the Department of Justice that also really make the timing important. In answer to Representative Roberts' question, the last section of the bill does relate to deaf and hard of hearing people, so there are some things that are included. I know that they also have some technical amendments that they would like to seek, and this bill might provide a title for that, and we would welcome that as well. Other than that, I'd just like to be available for questions if anyone has any.
Thank you.
Good morning, Mr. Chair and members of the committee. My name is Judge Mary Yu, and I'm here today on behalf of the Superior Court Judges Association, the Minority and Justice Commission, and at the invitation of Representative Santos. My comments flow from my experience as a judge for the last 13 years. I'm here to express our support for House Bill 1542, and our reasons are twofold. Ensuring that people understand legal proceedings is a matter of simple justice. Accurate interpretation by a qualified interpreter facilitates meaningful participation for people with limited English proficiency. We have a significant population who understand conversational English, and they're doing their best to learn to read and write the English language. However, because of language limitations, they are unable to understand legal proceedings, and without the assistance of an interpreter, frankly, they do not understand my court orders. They come from all walks of life. They include witnesses to crime, criminal defendants, children, victims of domestic violence, couples getting divorced, young adults facing eviction due to the lack of resources, and families in economic distress. If court hearings are to have any meaning, people need to understand the substance of the proceedings. Let me just comment very briefly. The second reason for our support, and I think you've already heard that mentioned, is because what might happen if you don't. I have led a number of presentations on the use of court interpreters, and one in particular with a Department of Justice attorney at the national level at a national audience of judges, and I can tell you that the Department of Justice is serious about enforcement. They've been clear that fiscal constraints are not an exemption from civil rights requirements. The forced consent decrees and settlements with state courts that are occurring around the country frankly end up being more cumbersome than what we could accomplish if we maintain control of the solutions ourselves. We've been innovative, resourceful, and lean in our administration, and we believe we could fulfill our obligations to provide an open and accessible court system with your support, and rather than having to be engaged in litigation with the Department of Justice. And so I respectfully urge your support and passage of this bill. Thank you.
Thank you. Please.
Good afternoon, Mr. Chair. My name is Latricia Kinlow. I'm the Tukwila Municipal Court Administrator, and I'm here to speak in support of House Bill 1542, and I want to thank Representative Santos for sponsoring this bill. We are one of the courts who is fortunate enough out of 40 to receive reimbursement from the Administrative Office of the Courts. Since that time, we have been able to increase the quality of interpreters that we hire for those who are in need of interpreter services in our courts. Without that funding, we would still be using, in some instances, what some courts are doing without the funding is using family members of those individuals to interpret for them. Therefore, we are not getting quality interpreter services. Also, there are 16 courts in King County, 16 municipal courts in King County that are participating in a payment plan, and as a result, only 9 of those courts receive reimbursement. So our commitment is proven by the fact that we are operating and doing everything we can to make sure that we are in compliance with the Department of Justice standards. We thank you for this opportunity, and we trust that you will continue to support this House bill.
Thank you. Do we have any questions for the panel? Okay. Thank you all for coming forward.
Next, may I please hear from Jillian Dutton, Christy Cruz, Ed Zaldibar, and Payne Lau.
Good afternoon, Chair Peterson, Representative Tomiko Santos, and members of the committee. For the record, I am Jillian Dutton, professor at Seattle University School of Law, and I thank you for sponsoring this legislation and for allowing me to speak in support. It allows our courts to get the funding they need to support services that are legally required in an efficient manner. My work on language access began when I started representing Spanish-speaking migrant farm workers as an attorney in Yakima, Washington, and continued for 15 years when I taught a refugee and immigrant advocacy clinic at the University of Washington Law School, where in the first 2 years we represented clients from over 38 different countries. Now at the Seattle University School of Law, where I direct and teach in the externship program, we have students working with LEP litigants in courts, with prosecuting attorneys, defense attorneys, and civil litigators. 2 years ago, Christy Cruz, who's here, and I were hired by the American Bar Association to draft the national standards for language access in state courts, adopted in February of last year. We worked with a national advisory group from around the country, Supreme Court justices, court administrators, the Conference of Court Justices, the National Center on State Courts, and the Department of Justice ex officio. These standards reflect the understanding that language access is a crucial civil right, not just for those who are limited English proficient, but also for the judges, court administrators, and English-speaking litigants who depend on the testimony of an LEP witness to ascertain the truth of the facts and to create an accurate record. It's important to know that the standards that have been passed and that are supported by this legislation really are for the benefit of all of us. These standards were also built on prior ABA resolutions that were calling for the use of interpreters in civil and in criminal proceedings on behalf of domestic violence victims and for attorneys who are representing LEP folks in civil cases. Removing the indigency standard, which this bill would do, is not only critical for federal law compliance, it will improve efficiency. As you've heard today, providing reimbursement allows the Administrative Office of Courts to standardize translated documents, coordinated work through interpreter pools or video remote interpreting,
I'm sorry,
and a non-unified court system.
Can I ask you to wrap up?
Thank you. These resources will allow the courts to move forward, and thank you for hearing this important bill.
Thank you.
Thank you, Chair Peterson, Representative Tomiko Santos, and members of the committee for the time to speak in support of this important legislation today. My name is Christy Cruz, and I'm an attorney at the Northwest Justice Project. RCW 2.43, as it stands now, creates obstacles to access to justice for LEP persons and confusion in its application in civil matters. For example, it's been used to limit the right to an interpreter in civil proceedings to something less than the full proceeding. A litigant can be denied the ability to call an LEP witness to testify because the litigant is not indigent. It requires LEP persons to attend an extra hearing to determine their income level and whether they qualify for a free interpreter. It creates a colloquy between judge and LEP litigants in English about whether the LEP person will be provided an interpreter at state expense. LEP persons in civil matters have to know that they can request a waiver. They have to understand how to request it. They have to go to an extra hearing, often without an interpreter or information in a written language that they understand. It also creates obstacles for courts in terms of court time. There is a cost to the IFP process that the state would save with these changes. House Bill 1542 goes a long way to ensuring that LEP persons are provided interpreters in all legal proceedings. It clarifies to LEP persons...
Can I ask you to wrap up?
Sure.
Thank you.
Well, I'll just say that anecdotally we know that IFPs most are granted, and so that really there is a cost savings that the state could be looking at. I encourage you to consider ensuring that the language in the bill is as clear as possible, that the intent is to provide interpreters for LEP persons in all legal and quasi-legal proceedings at no charge. Thank you.
Thank you. Representative Rodney has a question.
Thank you, Mr. Chair. Under the criminal law, individuals would be entitled to an interpreter if they were indigent and couldn't afford to pay. Under what basis does the state have an obligation to provide interpreter services in a civil matter where the individual is hiring an attorney? I think that's a little stretch.
Actually, Civil Rights Title VI of the Civil Rights Act 1964 requires meaningful access in all legal proceedings, and the DOJ has come out with guidance right lately, and Jill could probably address this as well, that clarifies that the obligation is to provide interpreters in all criminal and civil without an indigency standard or basis.
The complaint that, Judge, you referred to is based on the fact that the state courts are recipient of federal funds, and as a recipient of federal funds cannot discriminate on the basis of national origin, and there's a Supreme Court case, Lau versus Nichols, that finds that language is connected to national origin. So that's the basis there for the Department of Justice compliance. But there are also cases in certain civil matters that point out that the same due process that we need in a criminal case and the need to be, fully present at the hearing affects civil cases as well. There's just not as much jurisprudence in that area. Thank you.
Thank you. Please proceed.
And good afternoon, members of the committee. My name is Ed Saldivar. I am a Spanish certified court interpreter and CEO of eInterpreters, a software as a service company located in Everett, Snohomish County. We designed a web-based centralized interpreter management system named OneLingua, allowing for the consolidation of interpreter services by all state agencies as well as private sector organizations. So the software as a service procurement model enables direct contracting with interpreters, eliminating unnecessary and costly middlemen. For a very low monthly flat fee, the OneLingua system schedules interpreters for in-person, telephonic, and video interpreting by matching interpreters with search criteria preset by requesters, and OneLingua provides all the elements that are necessary for saving cost. Last year, the cities of Tukwila, SeaTac signed a contract with our company and successfully implemented OneLingua in their municipal courts, achieving up to 70% reduction in clerical time previously devoted to interpreted issues. This private-public partnership allowed for the reallocation of their court employees to other more pressing tasks. The information contained in the automated invoices is transferred electronically to customer auditing tools to provide the necessary measurable data AOC needs in order to verify the court's compliance with the Interpreter Expense Reimbursement Program, as well as the U.S. Department of Justice Language Access Guidelines. Therefore, Interpreter strongly supports HB 1542, seeking to expansion to all Washington state courts of the AOC Interpreter Expense Reimbursement Program. Thank you for your time.
Thank you. Please.
Good afternoon, members of the committee. I'm Ping Lau, a certified court interpreter for 2 languages, Mandarin and Cantonese. Before I joined the profession, I was an engineer and a computer modeler. Basically, I was interpreting for data instead of words. So let's talk about some numbers, as in money. $45 million. That is how much the state of Washington would stand to lose if our judicial system is not in compliance with Title VI of the Civil Rights Act. In the case of State of Washington versus Jose Morales, the Supreme Court overturned a criminal conviction last year due to questionable interpreting. Currently, the interpreter services of King County Superior Court is under investigation by the DOJ for potential violation. This court was not selected by the administrative office of the courts to receive reimbursement. Another very important function for this bill is to allow data collection. Data analysis is an extremely powerful tool. I'm certain some of our medical interpreter colleagues has made quite an impression on the legislature last year. And after they have implemented a new system, the projected savings for the next 24 months is going to be $13 million. Lastly, 49 years after the legislation of the Civil Rights Act 1964, we should not be treating anyone differently based on national origin or languages of differences. Washington is too good a state for that. Thank you.
Thank you. Do we have any further questions? Okay, thank you very much for coming forward. That'll conclude our public hearing on House Bill 1542.